Hi everyone, welcome to another week of presentations. This week we're talking about solitary confinement, titled Does the use of solitary confinement or administrative segregation constitute cruel and unusual punishment? Our group is a no group and is by Landry Hunter, Lainey Jensen, and myself, Diana. Solitary confinement, also known as administrative segregation, first started at the Walnut Street Jail in Philadelphia, Pennsylvania, in the late 18th century as something seen as a noble experiment. It was called a noble experiment because there were good intentions behind this new way of dealing with prisoners. They were trying to avoid corporal punishment and thought that this method would help with rehabilitating criminals. Due to the belief that solitary confinement would protect them from any outside influence and it was humane, it quickly spread to many other institutions, not only in America but Europe too. Why solitary confinement? While our group understands the negative effects that may come of solitary confinement, we have determined that it is a necessary function of prison control. There are a few instances that it is needed for the greater good. First, and for its primary purpose, is for other prisoners' safety. When an inmate poses a danger to others, it is a needed measure to ensure that a prison is a safe area for those inhabiting it. It is akin to when a child needs to be put in timeout for the good of the other children. The principle remains the same as an adult. In conjunction with prisoner safety, there are also instances where a prison may put an inmate into solitary confinement due to not following important regulations put forth by the system. For instance, we will later discuss a case where a prisoner refused a rehabilitation program that was necessary for his release. Courts have determined that so long as the conditions of the cell are humane, solitary confinement from a lack of discipline is legally protected. Once again, much the same as removing a child from a triggering environment to help them regulate. Finally, opting for solitary confinement in instances of protective custody for the prisoner are common. Oftentimes, depending on the crime of the inmate, other prisoners feel vindictive towards them. This could be as minimal as being part of the LGBTQ+ community or as severe as being convicted sex offender. As a result, such prisoners are often targeted by other inmates. For their own safety, a segregated area to keep them away from angry prisoners is beneficial for them in the long term. Regulations we would recommend. While we do place value within maintaining that solitary confinement is not considered cruel and unusual punishment, we do stand with the belief that there should be important regulations that influence how solitary confinement is handled. First and foremost, long-term solitary confinement does have undeniable effects on a person. This is not something that we recommend maintaining the standard of fair punishment. However, many states have implemented a limit on solitary confinement. Short-term solitary confinement avoids many of the concerns of psychological and physical damages that would potentially be caused by years alone. In fact, the United Nations Standard Minimum Rules for the Treatment of Prisoners, also called the Nelson Mandela Rule, advocate for no more than 15 consecutive days in solitary confinement. We have seen this positively implemented in nearly all 50 states. Connecticut and New Jersey have implemented the UNSMR and have restricted the length of stay for solitary confinement. Many of these laws also maintain the status quo of the necessity of having a purpose to the confinement. Often one of three reasons discussed previously: prisoner safety, disciplinary segregation, and protective custody. Second, the state of California has also made recent adjustments to the standard of solitary confinement, regulations that we find to be beneficial in creating an effective, safe punishment that follows the Eighth Amendment. The California Department of Corrections and Rehabilitation announced that solitary inmates would be allowed up to 20 hours of outside cell time per week. This is double what was originally offered, with 10 hours per week. In doing so, and keeping sentences to 15 days or under, solitary confinement becomes more humane, while keeping the prison system safe. Next, we will be reviewing major court cases involving solitary confinement. It is important to remember that the United States have continually upheld solitary confinement as being constitutional. Years of judicial and legislative precedent have determined that it is not considered cruel and unusual punishment, so long as the conditions are not extreme. In 1970, the Supreme Court heard a case titled Hutto versus Feeney. Hutto versus Feeney was brought to the Supreme Court due to Arkansas prison systems having negative conditions such as diet, sleeping arrangements, and behavior of prison guards. The court determined that much of how the prison operated suggested cruel and unusual punishment. However, Justice Stevens conceded that isolation was constitutional and may be an important interest that prisons would need to take, therefore upholding that solitary confinement is constitutional. Following that, in 1991, Wilson versus Cedar came about due to Wilson claiming he experienced cruel and unusual punishment. The court affirmed that Wilson needed to prove that the prison was deliberately choosing to harm him in his confinement or showed clear indifference to his conditions. This upheld that solitary confinement is constitutional, so long as there is not an intention or indifference to harming the prisoner. Bishop versus McCoy in 2002 determined that solitary can be needed to maintain prison safety. The petitioner of the case was a prisoner in Huntsville, West Virginia. He consistently started fights in the prison and threatened the safety of fellow prisoners. The court determined that the prison official made the correct call in placing Bishop in solitary confinement. Finally, McCoon versus Lyle in 2002 found that solitary confinement is legal if it serves legitimate penological interests. This came about following Robert Lyle being forced to participate in a sexual abuse treatment program. He refused as he felt it violated his right against compelled self-incrimination. He was therefore put into solitary confinement. The Supreme Court ruled that the program served a crucial purpose and refusal to participate does constitute as being an acceptable time to place a prisoner in solitary confinement. Regarding legislative measures that allow for solitary confinement, the list is quite long, particularly when it comes to individual state determinations. In 1994, the Violent Crime Control and Law Enforcement Act passed. The legislation included provisions that addressed the conditions in confinement and funded initiatives aimed at reducing violence in prisons. It allowed for the legitimization of more serious practices and considered solitary confinement to be a standard practice for managing inmate behavior. The Federal Bureau of Prisons also has a list of regulations that govern how solitary confinement is utilized. The policies have created the legal framework for putting inmates in solitary confinement, depending on safety and security needs. And of course, most states have state administrative detention regulations. These are the guidelines in place that allow solitary confinement to occur safely. That way, solitary confinement will not be exploited to be utilized in a cruel and unusual way. Examples include the California Department of Correction and Rehabilitation, who allow for solitary confinement if there is disruptive behavior, gang affiliation, or safety concerns. Additionally, The Texas Department of Criminal Justice has an administrative segregation policy for when prisoners are engaging in criminal behavior, refuse orders, or due to safety concerns from this, or due to safety concerns. From this, we can conclude that there are many judicial and legislative laws in place to ensure that both the prisoner system is maintained in a safe and humane manner. A few counterpoints that we would like to point out. Some claim that solitary confinement is not always successful, that the criminals, instead of taking the time to think about and reflect on what they have done wrong, spend most of their time thinking about what is happening to them in the now. They focus their time and energy to thinking about how cruel the punishment is and how they are feeling while being in total isolation. Although this may be true, there are also arguments that some inmates can benefit from this tactic and rehabilitate or reform themselves. Since the time they spend alone will allow them to take time and tap into their minds, this may help reflect on what they have done to be there. If there is any slight chance that solitary confinement may work, why not try it? As an example, I would like to use a personal example very briefly, and it would be I was dealing with health issues a while back, and one of the viable solutions was surgery. However, this was not guaranteed. In fact, it was a low percentage of success rate. I still took my chances because even if it were low chances that it would work, it was better than nothing. It worked. Another reason people may be against solitary confinement is that the criminal may be prone to mental illness disorders such as anxiety or claustrophobia, amongst other things. Despite this, putting someone in solitary confinement helps not only the criminal himself, but other inmates as well. It helps the facility to not have someone loose that can be of threat to other inmates. Keeping them isolated is of benefit to so many others. It is also concerning to some that solitary confinement violates human rights. Some people may argue that it is torture. This is a valid point and understandable concern. This argument is wrong because prison staff are using this method to control negative behavior and to maintain order. If the result of breaking prison rules were not harsh, it would be even more dangerous for everyone in the facility. Solitary confinement is not meant to be pretty. It is meant to deter criminals from doing more harm behind bars. In conclusion, safety and security must come first in correctional facilities. Sometimes that means separating contentious people until the situation diffuses itself. People are not sent to prison to be victimized by other inmates. Prisons are a form of rehabilitation for those that can reach that. And to constantly be forced to fight others defeats the purpose of that. Prison functionality relies on the condition of the guards and staff. If they get hurt, there really isn't much function to the facility. When we are looking to punish deviance, we remove an item of value from the inmate, punishment by removal. This is done in hopes that the inmate will want what was taken from them. There are many arguments about how solitary confinement is a bad thing. However, we feel that a place that is geared towards rehabilitation should do everything in its power to provide that. Staff and inmates need a safe space, and sometimes that requires the use of solitary confinement. Thank you for taking the time to get to the end. We have a few references on our last slide. Thank you, everybody.